Started. Turn my recording on. So, hello and welcome, everyone. Thank you so much for joining us today for the webinar Housing Justice in Georgia, Advancing Safe, Stable Homes for Every Child. I am Jill Walsh, the Assistant Director at Positive Childhood Alliance Georgia. And here at PCA Georgia, our mission is to prevent child abuse and neglect. And we do that through direct family support, through education, and through advocacy of how our communities and systems can best support families, especially to prevent them from coming or rising to the need of defects intervention. And we believe that housing is really more than a basic need. It is foundational for children and family for their well-being. So addressing housing needs early and connecting families to the right resources can help prevent that crisis, strengthen families, and reduce the likelihood of deeper involvement in defects. And so that is why I am very pleased. Um, Mute. Very pleased to introduce our presenter today, Luci Ruiz. She is the Housing Justice Policy Counsel at Georgia Appleseed Center for Law and Justice, where she works to advance local and state housing policy, really to help benefit children and families in our state. And I'm going to pass it off to her for any further introductions and to take it on.
Good morning, everyone, and thank you, Jill, for that introduction. That was a really good framing for today's webinar, because that is the basis of my presentation, is how important housing is. It is really the foundation of the family unit, because without stable housing, pretty much everything falls. So I'll be going over, uh-oh, already having technical difficulties. This is not good. Hopefully that doesn't happen again. Okay. And then the importance of early connection with families before a housing issue turns into a housing crisis. So I'll be presenting various resources to everyone this morning that you can share with families that you work with who may be experiencing some housing issues as they are in your line of work. And then also just some information about some new state tenant protections. Because I'm assuming many of you work with families who may be renting or may be experiencing housing instability. So these are really important protections to understand so that you can share this information with the families. And just because I'm an attorney and we can be so annoying with legal stuff. I just wanted to give a disclaimer at the beginning. Although I have an Esquire behind my name, I am not establishing an attorney-client relationship here this morning. I just wanted to say before we begin that today's presentation provides general legal information and advocacy education. It is intended to help you recognize housing issues, understand recent changes in Georgia landlord-tenant law, and know when a legal referral may be appropriate. But it's not formal legal advice and should not be relied upon to make decisions in an individual case, and does not create an attorney-client relationship. So please, also, I hope we're going to have a free-flowing discussion during today's webinar, and I would just ask to protect clients. Just please do not include client names or identifying details in the chat or during our discussion. I think we're all good with that. But does anyone have any questions about that before we begin? All right, let's rock and roll. So as Jill mentioned, I'm Luci Ruiz, and I am Georgia Appleseed's Policy Counsel. I manage our Housing Justice Initiative, which advances both statewide and local policies that impact Georgia families, primarily with school-age children that are experiencing either issues that impact their stable housing. So that can look anywhere from I cannot afford my rent today, and therefore I'm at a risk of being evicted, all the way to I am living in my car and need assistance connecting with my local COC. And then we also advocate for policies to strengthen safe and healthy housing for families and children. So that primarily deals with the condition of a family's household. All right. And my canine coworker, I guess, has some opinions already. So sorry about that. He may be legal pipe down during this presentation. Just to give everybody a good overview of today, we will be covering the following topics, which is housing justice and child welfare, Georgia Appleseed and our statewide collaboration, just to give you an idea of who we are. I know some of you already do work with us, but some may not. And then two specific laws that were recently passed in Georgia, the Safe at Home Act, and then Senate Bill 406, which deals with eviction records, and then some resources to provide to you all as well that you can share with the families you work with related to healthy housing advocacy. And then at the end, just some real practical advocacy tips, referrals to resources, and then an open discussion about what y'all are seeing in your daily work. Just as a matter of housekeeping, I'm not able to see the chat just on my screen. So Jill's going to help me out to make sure that I don't miss any questions or anybody raising their hand. But questions may be submitted throughout this presentation. I'm fine taking a pause and addressing any questions or discussion topics that you'd like to bring up. I will also intentionally pause after the Safe at Home Act discussion and the SB 406 sections to answer questions from the chat, since those are more legally focused. All right, since it's 10 a.m. on a Thursday, and I'm sure we've all had a really busy week, I thought we could start out just with a brief poll to get everybody just starting to connect and get the energy flowing. So hopefully this is the first time I've done this without actually having a poll for people to click. But I'd like to ask if you could indicate in the chat either a letter or letters that apply to you regarding this question. So my opening chat question is, where does housing show up in your work? I'd really like you to think about that, because it typically shows up, it's a constant daily issue for families. So please type the letter that best describes the housing problem you encounter most often. Letter A is unsafe or unhealthy housing conditions. Letter B is non-payment of rent, eviction notices, or court filings. Letter C is hotels, shelters, doubled up housing, or homelessness. Letter D is application denials, deposits, or tenant screening barriers. Letter E is utility interruption, lockouts, or landlord communication. And then F is something else. So that's just open to whatever else you are seeing. And if you would like to indicate if F is your answer, you don't mind elaborating a little bit more on what that something else is. And Jill, once people start entering in the chat, if you wouldn't mind just reading 2 or 3 of the responses so that I can acknowledge them, I'll make sure to address these issues throughout my presentation as well. And I'm going to try to excuse my canine coworker while we're in here, since he's just not wanting to cooperate. 1 second.
Yeah. And I'll give everyone one more second to put it in. So if you put F, which I think there are 2 of you, if you want to elaborate what that something else is. Okay, thank you. So we got the most responses for letter C, followed by B, then A. We had a few at E, and then just the smallest amount at D and F. So C and B seem to be the biggest issues, followed by A. And for those who put other, it was transitional housing for youth who are exiting out of care. But there are also a number of factors that combine with that, and then also child care providers.
Great. I'm writing these down.
So
Yeah, and
see,
that that is not a surprise at all because unfortunately our families, due to us having a lack of housing supply across the state, are having to turn to alternative housing that is less stable, hotels, shelters, doubled up housing, homelessness, particularly families with young children. So that is something I will cover today. That's actually the primary slides I'm about to go over. So very relevant today. And I'd love to have a bigger discussion about this. I'm just making an assumption that probably B may be leading, B and A may be leading people into C. That's really when the family has reached a housing crisis. They're out of their stable rental housing or home ownership, and they're looking for last minute housing, either due to being in an unsafe home or these barriers, non-payment of rent, being evicted, some kind of court battle going on that's preventing them from being able to secure more stable housing. So thank you everybody for participating. And I will continue to acknowledge those responses as I go. And then I'm especially interested too to go over a little bit more of people who are working with transitional age youth. That does also, that is a issue that we are working on with Georgia Appleseed right now, particularly around the vouchers with the Department of Community Affairs and DFACS. And so I'm happy to answer more specific questions about that towards the end of our presentation. Okay, so why housing justice is a child welfare issue? I don't think I need to really go into detail about that. I think we're all under a common understanding, particularly you all who are on the front line working in this day to day. You know how much lack of stable housing impacts children, particularly our youngest children, 0 to 5. It can really impact their overall development and child outcomes. But where they all coincide is a lack of a stable home then turns into impacts on education and childhood development, as well as a child's physical health and sense of safety and mental health, and and as well family preservation and reunification. Lack of stable housing is, I believe, cited as the top 3 reason why families maybe entering into the child welfare system. And so it's very important for us to have early intervention to prevent something like that happening, which I'm sure many of you are already working on. But housing connects these 3 important areas of the child welfare infrastructure. And what I mean by that is a child's housing situation affects far more than where the child sleeps. For example, housing conditions can affect a child's physical health. There is a lot of evidence to support that a home that is filled with mold or poor ventilation um, increases a child's risk of asthma, can impact a child's ability to get a good night's sleep. Lack of safe kitchen facilities impacts a child's ability to have healthy nutrition every day. And then frequent moves have detrimental effects on a child's mental health, even later in life. There was a recent study that came out that housing instability experienced at a very early age actually increases a child's likelihood to experience teenage depression and anxiety, as well as behavioral issues. My prior career before I entered policy work is I was a juvenile delinquency public defender. And I saw that constantly with my young clients who were experiencing housing instability and just how much that could impact their behavior at school, simply because they were extremely tired. They were living in a house that didn't have adequate power, didn't have adequate air, and just how much that displayed when they were outside of the home. Um, and then housing instability can also affect a caregiver's ability to maintain employment, maintain important appointments, all of those things. They have a secondary impact on all of the conditions listed for the child. They cause Housing instability causes disruption to the child's daily sense of stability. causing frequent school moves, absenteeism, transportation problems, loss of services, disrupted routines, and behavioral stress. Bottom line, a housing problem is not automatically evidence of a parenting problem. It's evidence of a systematic problem. So it's important to ask what resource, repair, accommodation, income support, or legal intervention might be missing for this family. And I do have a resource I can share with everybody. Doesn't want to open right now. But I told Jill I will make sure after this presentation to share with her any resources Georgia Appleseed has, including data that I'm referring to, so that you all have that for your needs. And it was just a flyer with child homelessness data and just the impacts that housing has on child well-being. Okay, so getting into the extended stay hotel issue and what that reveals about Georgia's housing system. Some of you may be aware of the study that was recently conducted by Georgia State, their School of Public Health. It dove into households that were residing in extended stay hotels located within DeKalb County. I believe they surveyed 18 extended stay hotels in DeKalb County to determine, use the data to inform what are the specific barriers that are leading these families into these living situations, and just to understand this issue a bit more. And so I've inserted an infographic here. I can also share that study with Jill so that she can share that with you all. But some big takeaways here were this 2026 study surveyed DeKalb County households, as I mentioned, that were residing in extended stay hotels, and found the following. There were 4,664 individuals that resided in DeKalb County hotels. Of those individuals, 1,635 were children. And this is such a common space for children to be residing in now. Most schools do have bus stops located outside of these extended stay hotels, as if they were just regular neighborhoods. And how we look at this, or how this study really looked at it, was 4 factors. There's access barriers as to why these families are going into these what used to be temporary shelters but are now becoming more permanent shelters, but that's access. Families cannot pass tenant screening requirements often for various reasons. That can look like lack of having a certain credit score. It can look like having an eviction filing on their record. It could even just be things like, hey, I was in this home and my children were loud and I got kicked out, and that continues to be reported. This really impacts particularly single mothers with young children, where we see that. Then conditions, the available housing that a family can afford may be unsafe or unsuitable. Not saying that extended stays are any more suitable, but sometimes that's the only house that these families can find that have a roof to supply over their children's head. And then the cost. Families are paying high weekly or daily rates to these hotels and cannot save enough money for, 1, a security deposit, and 2, to make their first month's rent on top of that. That keeps them in these hotels. And then accountability. Hotels and landlords are typically difficult to reach or hold responsible. Hotel owners do not have the same duties to keep their residents safely housed as landlords do, which then in turn puts these families in kind of a risky housing situation. So just getting back to the Georgia State study, It found that most surveyed households had a working adult, yet families remain locked out of conventional rental housing by screening rules, deposits, credit, prior evictions, and other barriers. The top access barriers that they cited were 61% of those surveys cited income screening requirements being the top barrier as to why they could not secure more stable traditional rental housing. And what I've experienced a lot just in my line of work is many people who are working poor. So that looks like Uber drivers, delivery drivers. They're not able to supply a consistent pay stub because they're self-employed. That can be a major barrier to them being able to get into housing. Then outside of just income screening requirements, 48% cited that they could not afford a security deposit. And that is why they cannot access traditional rental housing. And then the third group, 33% cited a prior eviction as the primary barrier to keeping them in less stable extended stay living. And these families are not paying less because they live in a hotel. They're often paying as much or more than apartment rent for less space, less stability, and fewer meaningful protections guaranteed to legal tenants. It found that the average monthly hotel cost in DeKalb County was $1,852, while the average DeKalb rent for a single bedroom was $1,789. And I do want to note, it's probably not a surprise to anyone who works with families who are residing in extended stay hotels, but those are also typically one bedroom just with multiple beds in it that a whole family is living in. So that's why it compares a single room apartment in the rent calculations. So I do want to open this up to a discussion, whether you want to put it in the chat or raise your hand and share. But which of these barriers could your agency or organization identify or address earlier, even if your agency cannot solve it alone? And so does that look like identifying school stability services, for example, referrals for McKinney-Vento, because these families do qualify for McKinney-Vento, or helping families gather documentation, locating deposit and rental assistance, making a legal referral before a court deadline, coordinating health documentation, or connecting a family to code enforcement or a housing navigator. Those are just all examples to ponder. But just a reminder, the discussion topic is, which of these barriers could your agency identify or address earlier, even if your agency cannot solve it alone? So whether that's an access barrier or an accountability barrier, cost barrier, condition barrier. What are your thoughts on that?
Hi, I would say for my area, I am in rural South Georgia,
Mm-hmm.
very rural area. And what impacts our families most is the conditions. The slumlords here are running rampant, just treating people horribly. And when you try to refer to code enforcement, most of the families, they get upset with you or they pull back from you because once you do that, then the landlords play these tricks and they end up, you know, evicting you or pressuring them out and they don't have anywhere else to go. Um,
Mm.
so that is like one of them, aside from the cost that they charge them to live in these almost dilapidated homes, the conditions is deplorable almost here.
And Chantel, thank you so much for sharing that. Are you seeing that the families, because of this fear that landlords have created down there, they're scared to voice any
Mhm.
condition complaints because they'd rather be in a dilapidated home than living out of their car or not living in an extended stay hotel? Just it's nice to still have that stable roof over their head in a community that they're familiar with.
Yes, because most of them, a lot of them are like self-employed. Some are cleaners. Some of them do drive for Spark or different stuff.
Yeah.
Um, and there are some that work like regular job, McDonald's, Burger King, like that. But then they can't afford the extended stays because the extended stays are a lot per week. Some of
Right.
them, I think you only have like most of them here are you have to pay your thing every week. And it's a lot when you can just they would rather pay it once a month, even though it kind of almost comes out the same, but they're looking at it like this is my place. I don't have to share it with anyone else. And most of them are afraid that if they get evicted or whatever, defects are going to take their kids. So they're afraid of the defect system. So they're not really willing to push the envelope too much when it comes to landlords.
Yeah. Yeah. No, thank you for sharing that. I know in this study that was definitely what many families voiced. And you speak to the point that whether you are in metro Atlanta or you are living in rural Georgia,
Hmm.
this is not just a regional issue, it's a statewide. So
Hmm.
thank you for
And
sharing that.
the new, I know there was a couple that kind of some community partners felt some relief when the I think the new laws or whatever was supposed to be rolled out.
Yeah.
Um, but then when the what became is so discouraging is that we Georgia has all these tenant laws now, but there's no consequence or penalty. So you can report these once that bill passed, you can they say you can't charge three times the rent or you can't do this or you can't do that, but there's no penalty if they are doing it. So it's like you passed the law and said don't do it. That's almost like telling a child like don't sit there and eat all that candy, you're gonna get sick. And then you sit there and watch them eat all the candy. Like
Yes, that's a good way to put it.
yeah.
Yeah. And I'll go over some of that more within my presentation because I do have some resources, particularly with that. But yeah, there are some shortcomings even with our tenant protections, as great as it was that they were passed. Lack of being able to enforce them and is a problem that advocates um, are trying to address with our legislature. Do you mind, Chantel, reminding me? I know you work in rural Georgia, but where in particular? You don't have to reveal the agency, just like the county or the city or the region.
um I think we're in region 11. I think it's more Lanier Lowndes Berry
Gotcha.
area.
Okay.
I think it's region 11.
You're, you're in one of those lovely legal deserts down there in Valdosta.
Yes, I am.
Okay. Okay. Oh
It's
man.
yeah.
Okay. Is there anybody else who wants to share or can relate what Chantel shared before we move on?
I did not see anything else in the chat box, but I did put
Okay.
the link to those findings in there for everyone. And that
Thank
study was
you.
actually done in part out of our larger research organization. So I remember them
Yay.
recruiting volunteers to go look at there because it was like a mile from my house and seeing all of it. So
Yeah.
very localized. Thank you, Chantel, for sharing.
Thank you, Jill, for being part of that study because it's been very eye-opening for lawmakers. So thank you. All right. So moving away from just the data and the issues that we all are very familiar with, particularly everyone on this call, I do want to just highlight just briefly Georgia Appleseed's housing work and our statewide collaboration so that you all know just where we're coming from in this space. Um, Georgia Appleseed is a statewide nonprofit. We're part of a national network, the National Appleseed Network. We even have a office in Mexico. So I guess we're part of an international network. But all of our centers are focused on some form of systemic change. So for Georgia Appleseed, we focus on systems that impact traditionally K through 12, but we're starting to expand to working with the 0 to 5 population, as well as youth who are transitioning out of foster care. So our housing justice initiative in particular focuses on state and local policies that impact the health and safety as well as stability of housing for families with school-age children. And how we do that is we equip advocates with educational resources or and particularly like advocacy materials. I will share one of those with you all today. And when I say advocacy, that can look anywhere from, hey, I'm at the Capitol talking to my representative, to I am getting my neighbors together because we are experiencing dilapidated housing in our neighborhood, and we want our commissioners to know and do something about it. To I am telling my landlord, I'm advocating for my family to my landlord that um, sewage is coming into my home and they need to fix that. How do I do that effectively? All of those are forms of advocacy. So I just want to dispel that this is not just going to the Capitol and talking to lawmakers. We also work to strengthen the judicial system. So that can look anywhere from a new law was just passed. Let's make sure that we're working with courts so they, one, know about that new law, and two, are applying that pretty uniformly so that there are consistent results for Georgia families. And then three, we advance policy and legal protections. That's just pretty much what it sounds like. And then we connect individual experiences to reform. We do not advocate for any policies that the community voice has not informed us of. So we travel across the state throughout the year so that we can meet with various service providers and local lawmakers to understand what local challenges are and how that can inform state policy changes. And a big part of my job is that I lead and convene our statewide housing coalition, which is called the Georgia Healthy Housing Coalition. You know, we're in the nonprofit child welfare space. So of course we shorten that to an acronym, which is GHHC. So I'll be using that acronym throughout this presentation just because the other one is a mouthful. But GHHC was founded in 2018. Since our founding, we have more than 80 dedicated organizations that are active within our coalition, all the way down from Valdosta all the way up to the city of Dalton. And these organizations are either regional or they are statewide. We do have some that also have a national presence. And during our first couple of years, we realized that unfortunately in housing, we're really good at working in silos and not so much working collaboratively, or we find ourselves really working regionally and not working statewide. So many of our members came together to develop a 10-year advocacy plan that drives our policy priorities, both locally and statewide. That's informed by direct service providers as well as tenant voices. And I will make sure to share all that with Jill so she can share that with you all after today's presentation. But our coalition works together to advocate for law changes, policy changes, implementation of those changes, and then a public education piece, making sure that statewide renting families know about changes that impact them. And this is just a picture of us. Last year, we had our first Healthy Housing Day at the Capitol. And so that is our primary cohort. We were fortunate enough to even have some former foster youth who spoke. And we had lawmakers from both sides that came out and spoke as well about housing policies that they are seeking to advance and hear from our partners and the former foster youth. But why it is so important for all of us, not just dedicated housing advocates, but all of us who touch this space in some manner, is because no one organization sees the entire housing system. Child welfare agencies see family stress and placement barriers. Schools see attendance and enrollment problems. Health providers see asthma and environmental conditions. Courts see eviction cases. And I could go on and on and on about the different lenses we're seeing, but we cannot have a comprehensive housing change in this state without bringing all of those voices together to ensure that our policies um, are effective for addressing why families are in the state right now. Um, and just a few highlights, and I will go over these much more detail soon in this presentation. But in 2018, as I said, GHHC was founded, and our primary founding partners, some of you may be familiar with them, are Sawega Rising, that's located in Albany, Georgia. Georgia Act, they are based here in Metro Atlanta. However, they have a statewide presence, particularly in rural Georgia. And then Neighbor Works Columbus, which is a housing service provider located in Columbus, Georgia. And since our founding, the first big win that our group had was in 2019. That's where we worked to advocate for the successful passage of House Bill 346, which is Georgia's anti-retaliation law. As was spoken to earlier, families experience fear of retaliation by voicing code complaints or requests for condition repairs, condition maintenance. This law is supposed to protect them. It is illegal for landlords to evict a family simply because they are speaking up about a condition in their home that is impacting their health and safety. So that's an important law that courts should be enforcing, but I know there are challenges there. Then in 2022, that's when we passed our 10-year strategic plan, which still guides us here today. And then in 2024, that's where our partners worked statewide to diligently pass House Bill 404, which is Georgia's Safe at Home Act. This is just a picture of our rights card. It's a little wallet card that tenants can carry around that just lists their basic rights under that act, as well as links to a QR code that takes them to our dedicated resource page. And then in 2026, GHHC also worked together to get Senate Bill 406 passed, which is the eviction record. Within that bill, it's a much bigger bill, but there is an eviction record provision in it that I'll go over towards the end of my presentation.
Excuse me.
Get into.
You said it's hard that tenants can carry to.
Yeah, it's a little wallet card that tenants can carry with them that outlines the four protections that are in the Safe at Home Act. And then it also has a QR code on the back so that they can be directed to a resource page that gives them like letter that they can use to voice any complaints to their landlord and just much more detail about those protections.
So how do we get that card?
I can, it's on our website, which I'm going to provide to Jill, that
I
resource
just put
page.
it in the chat. Sorry
Oh,
to
you're the
interrupt you.
best,
I
Joe.
just put it on the chat. I believe I have the right one. It's one page. It has the four rights and the QR code. So I
Mhm.
have the main page. You can download it in multiple languages, and I have the English one at the very bottom in the chat.
You are the best. Thank you. And then if anybody needs like physical copies, I'm also happy to mail those to you. If you want to put that in the chat where to mail them, I can do that as well. And I'll also share my email at the end of this. You can reach out to me. Happy to send any physical resources to you. Okay, so the Safe at Home Act and Senate Bill 406, which I'm about to go into much more detail, but just as a kind of foundation, those did not begin as abstract ideas at the Georgia Capitol. They began with patterns. Families living in dangerous homes, families receiving inadequate notice, families being denied housing because an old court filing continued to follow them. Particularly the anti-retaliation law um, was our first law that we worked to pass because we were continuously hearing from the families we serve through our school justice program that their children were missing significant um, amounts of school due to health conditions that were caused by poor living conditions. And when they would voice that to their landlord, they were then finding that they were getting kicked out of their home or the landlord's just doing nothing. So that is why we advocated for that law, and lawmakers actually agreed to pass it. Um, but this is just a circular, a cyclical cycle. I don't know why I'm trying to use big words that are just not even coming out of my mouth. But this is the cycle of system change and how Georgia Appleseed approaches systemic policy change. And that looks like this: connecting with children, families, and communities. That is the first step. We cannot make significant change that actually impacts families if we don't know what they want and what they're experiencing. Um, and then from that, identifying recurring gaps. So, like this morning, it's seen there are recurring gaps that everyone is seeing based on how you answered the first question: A, B, C, D, E, F, G. Um, that's something you're seeing on a daily basis. And then taking that information and applying legal and policy expertise. We connect with, well, we do have, I think, 5 attorneys on staff that are policy experts. And then we also recruit law firms who provide pro bono voluntary research to us to actually be able to draft policies that we're advocating for at the Capitol. Then from there, it's building the public narrative. Storytelling is the most effective way to make change. Because I can speak as Luci Ruiz all day long, but I'm not the same family who is living in an extended stay hotel. They can speak to their situation, and that is very impactful at the Capitol for lawmakers to hear that these are your real constituents and this is really what is going on. So building that public narrative. And then educating and cultivating allies. We cannot do this alone. It takes an army to make significant change. So it's really important for families to connect together because they'll not only find community and that they're not the only ones who are experiencing this, but there is power in numbers. And then advancing and actually implementing reform. When we get a law passed, it's important that it is implemented in a consistent manner so that just because you live in Bullitt County, you're not getting any less protection than as if you lived in DeKalb County, because state law applies no matter where you live. And we all on this webinar, we all play an important advocacy role. That does not mean the traditional role, as I stated earlier. You don't need to lobby to contribute useful information to make statewide change. And de-identified trends matter. A bit how we were actually able to get eviction reform passed this past session was providing the McKinney-Vento numbers of the number of children in each Senate district and House district of children who were receiving McKinney-Vento services in their districts. Lawmakers had no idea that many school-age children were experiencing housing instability. And the primary reason why was because their uh, their family had an eviction filing on their record. So that was very impactful, and that's how we were able to do that. And as said at the beginning of this call, just the importance of early intervention. I encourage everyone to identify how they can share systemic observations without disclosing confidential client information. When you're seeing this on a daily basis, it is so important to share that because these are families who are about to be in a serious housing crisis that impacts them for years to come. And so the only way we can change is to make systemic change. And you guys are the ones who are seeing it daily. So let's go into the meat of this now. We'll transition to more of our law focus of today's webinar, and that's looking at House Bill 404, Senate Bill 406. I'll show how this process can address different points in a family housing journey. So the Safe at Home Act, that is the name of this law. However, you'll still hear people use House Bill 404 just because it was such a significant piece of legislation. It's still referred to as that, but either one is the same law. And before I go into that specific law, just as a primer, there were two reforms, but one housing stability goal. That's why we focused on these two issues over the past couple of years. The Safe at Home Act addresses conditions, utilities, security deposits, and the pre-filing process for certain non-payment evictions. And it went into effect in Georgia on July 1st, 2024. So that is a protection that is legally sound right now. Then Senate Bill 406, that is part of the Georgia Property Owners Bill of Rights Act. You may have heard your local government talking about this because the majority of the law has to deal with homeowner associations. But there's this little section within it called Section 8 that will go into legal effect on January 1st of 2027. And that addresses the continuing public availability of certain eviction records, which legally that's called a dispossessory record from a dispossessory proceeding. I do not like using that word. There are too many S's. So familiarity eviction. And together, these two laws address two different moments within the housing continuum: maintaining a safe and stable current home, and then preventing an eligible court record from becoming a permanent barrier to accessing future housing. So when the Safe at Home Act passed, what actually changed for Georgia tenants? And just I won't get political, but I will just say this law needs to get more beef, as Chantel could speak to with her experience. We need some more teeth to it so that it can be more enforceable. But here's where we're at with it. It was a significant step, even though there's still more work to be done. The Safe at Home Act applies to residential leases that are entered into or renewed on or after July 1st of 2024. So that's really important. It doesn't mean that just because it passed, it applies to someone who entered a lease in 2020 and somehow is still under those lease terms. That date is significant. And the four principal changes to landlord-tenant law under this act are: the premise must be fit for human habitation. Utilities now expressly includes cooling. Heat, light, and water were always within the definition of utilities, but hey, we live in Georgia. We should definitely include air conditioning as part of a necessary utility in housing. So that was included as well. And then it put a cap on security deposits. They cannot exceed 2 months rent. And that includes like any introductory fees, anything that cannot exceed more than 2 months rent. And then certain non-payment evictions require a written notice and 3 business days. It's called the right to cure. And that's an opportunity to pay or vacate before the landlord can actually go down to the magistrate court and file for an eviction. So just some practical tidbits with this law. Always begin by asking when the lease was entered into or last renewed to ensure A, it actually applies. Do not assume the law applies merely because the problem occurred after July 1st, 2024. Where it's triggered is what was the actual lease start date or the renewal date. The Safe at Home Act was historic, but it was very targeted. It did not resolve every landlord-tenant issue. It is merely just a start. And it does not create a comprehensive right to local rent control authority, for example, a general tenant right to withhold rent, automatic right to legal representation in these types of matters. But there are legal service providers who can represent tenants when they're experiencing a habitability issue, which will provide those contacts after this call. But the purpose of today's presentation is merely to identify issues based on your frontline experience, not to decide how a court will rule in the individual's case. I'm not asking anyone on this call to be a tenant landlord attorney. It's merely so that you can issue spot and know, hey, I need to refer this client for additional legal review. So as I mentioned, this was one of the biggest protections that came out of this legislation. And that was Georgia actually putting in our book of laws that residential rental homes must include a provision within the lease that the premise is fit for human habitation. That is not something that a landlord can write in the lease. This is waived or anything. They have a duty to not only supply a home that is fit for human habitation, they also have a duty throughout the duration of the lease to maintain the home to be fit for human habitation. Now, the issue is the legislature left the definition of what fit for human habitation means for the courts to decide. We do have some guidance on some from some other property law as to what that could mean, but we have yet for the courts to clearly define it. And you are not required to make that decision either, but just some issues some issues to spot when a family comes to you with condition issues in their home that could be potentially habitability concerns would be no reliable water, heat, electricity, or sanitation, serious leaks or sewage coming into the home, unsafe structure issues, persistent mold or pest infestation, broken exterior doors or windows, and then conditions that aggravate a child's medical needs tend to be ones that the court may consider to be an actual habitability issue. And then, like I mentioned, fit for human habitation is a legal standard. It's not a complete checklist at all. It's really going to be up to the facts of the case for the court to decide. They don't have just a uniform, oh, I see you have this, so, landlord, you got to fix this now. It's really up to the specific facts of the case. A minor cosmetic problem, typically that's like, paint, a hole in the wall, things like that. I don't agree that that's necessarily minor, but the court may see that it's minor. That is not the same as a serious health or safety condition that is affecting the habitability of the home. These are really things that are making it to the point that it is not safe for the family to be in this home any longer. And then the severity, duration, landlord notice, effect on the family, repair history, and supporting evidence may matter in these cases. So it's very important to encourage the families to document everything, take photos, preserve every letter communication that they have with their landlord, code enforcement, any of that. Because if they're trying to build a case, that is stuff that is really necessary. And an important question to ask the families you serve if they bring this up is ask them, have they notified their landlord in writing? It's important if they have a face-to-face conversation with their landlord, and we encourage that should be this process. We shouldn't have to go all the way to court. Most landlords are open to fixing homes. We know there are very bad actors out there, but we want to encourage just informal communication with your landlord, letting them know this is going on. I need you to fix this. Follow that conversation up though with a writing, whether it's sending an email or sending a letter. It's very important because then that's your written proof that I had this communication on this date. And as I mentioned, our Safe at Home Act resource page does have a template letter that that families can use if they're dealing with a situation like this. And then if they voice that their child is experiencing potentially health-related challenges that were caused by housing conditions, it's important that they have that documented. Every doctor visit, anything like that, and especially if a doctor has suspicions that that may be what's going on, it's important that they have those records. And then also asking whether code enforcement has come out to inspect the property. Because if code enforcement has, it's important that they get a copy of that inspection report to add to their case as well. And then moving beyond the habitability issue, two other significant protections that came out of this act, which have been pretty much effective in curbing some of this, is the utilities. Georgia's legal definition of utilities now expressly includes that cooling is a necessary utility that the landlord cannot interfere with or disrupt the service connection during the pendency of an eviction or like some type of rental dispute. It does not necessarily mean that the landlord has to provide a cooling system at move-in, but if they are, they cannot cut that service off just because they maybe have filed for an eviction or they're having some dispute with the tenant. That would violate this law. And then in addition to that, there is now the security deposit cap. Security deposits, unfortunately, are still very unaffordable and a primary barrier, as we saw from the GSU study, as to why families cannot secure stable rental housing. However, the law does cap a security deposit at the equivalent of 2 months rent, because prior to this, we were seeing where security deposits could equate to 4 times rent, which who has that when the average rent for a single family bedroom is almost $1,800. And so the intent of this is to encourage families to be able to more readily access. Then finally, and this is something in particular, legal aid has had success in challenging in court. It's an important eviction protection for tenants and those who may be experiencing a dispute, a rental payment dispute. That's notice and the opportunity to cure. So what this means is, your rent comes due, whatever the due date is. And let's say the tenant is not able to pay rent and they don't. So the landlord is now required to provide a written notice, pay or vacate notice, before they can go down to the magistrate court and actually file for an eviction. And this notice has to be posted. That's conspicuously, so it has to be very visible on the front door in an envelope that has the date of the postage of when they're posting that notice. And then from there, they have to allow the tenant 3 business days to make a decision, whether that's paying the rent and any late fees, whatever all the fees that are due within 3 business days of that notice, or making the decision to vacate. If the landlord does not adhere to that 3 business day threshold, the court will throw out their eviction filing. So they can't even like pre-file before that 3 days. They must wait. And so we consider this a pre-filing protection. And it is important to note that that notice from the landlord, that is not the same thing as the court papers that a tenant will get when this process starts, this eviction process.
So
So
can I just clarify, make sure I understand?
yeah,
Because this is the problem. Okay, so the landlord has to give them a notice, written notice, 30 days prior, and then allow them 3 days to either stay or pay, and then they can file?
not 30 days prior. They have, so whenever that rent becomes due and they don't pay it,
Mhm.
then the landlord, whenever they're trying to collect that rent and move for an eviction, they have to put that notice on the door.
Okay.
It doesn't say like when that notice needs to be on there. It's just whenever they are making the decision, I'm going to go down to the court and file. Then from the date that they have posted that notice on the door, they have to give the tenant 3 business days to either pay or vacate before the landlord then can actually go to the magistrate court and file for an eviction.
So the rent could be due on the first, and they can not pay it. Let's say the first, and they can say, okay, the third, we're going to give you this notice because we're going to file, and then they have to give you until like the 6th, pretty much.
Yes, exactly. Yeah.
Louise. Okay.
Yeah. And it's not clear in the law whether actually it is, never mind. It's 3 business days. So like, let's say like this is happening on a Thursday, they may still have Saturday and Sunday to pay as well before they can. So if that makes sense, but it's calculated by business days, not calendar days.
Okay.
And this circumstance only applies in non-payment of rent disputes. It does not apply to like damage issues, other reasons why an eviction may be filed. It's solely non-payment to encourage these informal discussions between landlord and tenant and try to curb just the immediate court intervention when this could have been solved just between the landlord and the tenant without the court. And also the notice, if there is any provision within the lease that says they have to deliver this notice by some other means as well, like that can be like by text, by their rent portal, whatever, they also have to adhere to that. So that's also important as well. And that's an important provision that the tenant should make sure they see in the lease, highlight it so that they know. Um, and it's important too to just let families that you're working with, if they may be like about to be in this situation or currently in this situation, if they try to pay, because that will happen sometimes where the tenant is trying to pay and the landlord is really using the late payment as a convenient reason to kick them out of their house. And they'll just refuse to take the payment, or they may be dealing with a portal that won't take a late payment. It's important that the tenant still preserve proof of their efforts to make the payment within these 3 business days. So that can look anywhere from a payment confirmation screen, email, a witness, rejected electronic payment, just anything that they have to show proof of their efforts. It's important for if this is going to particularly go to trial. I mean, not trial, to the court. And these are just some practical ways that you all can help these families to enforce this protection a bit more, is asking them, when was the lease entered into or renewed? What happened and on what dates? Has the landlord received written notice? Has the family received a landlord notice report papers? Those type of questions. You're not asking because you're trying to build a legal case. It's just so you're documenting and helping them document just the facts of this case and encouraging them to preserve all of these documents, evidence that they may have, and then referring them as quickly as possible. Um, so whether that looks like, and when I say refer, this is typically going to be referring them to a legal aid provider so that they can actually review the situation and let them know how to proceed from there. And I did mention that I would pause after the Safe at Home Act portion of this presentation, just because I know I threw a lot of information at y'all. Were there any questions that anybody had or anything you wanted to share before I get into eviction records?
I have a question.
Yeah.
Hi, I'm in Bullitt County, and I had someone share with me something that happened to them years ago. And as you talked, it reminded me of that. He and his family were being evicted, and they were packing up. But the landlord kept having their electricity turned off while they were
Hmm.
trying to, take care of things. And the person told me they reached out to the power company and had it turned back on. And then the landlord got it shut off again. And it just made him go, I got to get out of this place. I mean, from what you just said, that's making me think that it, is illegal to do that now. Or is it? Am I hearing that wrong?
Yeah, I mean, based on the facts that you're providing, that does sound like that's falling within the range of a possible retaliation issue
Mhm.
and a violation of the landlord's duty to furnish utility services. So, like I mentioned, like with the cooling issue, they cannot disrupt or suspend um, utilities, including electricity, during an eviction proceeding. Like you've got to wait until it's finalized. So I don't know where they were in that eviction process, but it does sound like that was a potential legal issue um, that maybe they could have been referred to an attorney to help them sort out. So where are they? Do you know where they are now?
That had happened. He just shared it with me. That had
Yeah.
happened some years ago. And it was here in Bullitt County. So as you were talking, I definitely want to reach out to you to get some of the printed materials to have on hand, to
Definitely.
share with people and get them not only to people that might be encountering this, but to some of my colleagues, to make them educated and aware and that they can provide it to their, program participants as well. So this has been great. Thank
Yeah,
you.
yeah, I'm happy to share that. Thank you, Laura, for sharing. Is there anyone else before I move on to eviction records? Okay, thanks, Jill. Okay, so Senate Bill 406, Section 8. This is the eviction record provision. Go to my notes on here. Um, so an eviction filing can outlast the eviction case. And when it's an important distinction, I keep using eviction filing. That is merely what it sounds like, filing for an eviction, the landlord doing that. That does not mean that the court has actually ruled on the eviction in the tenant's favor, landlord's favor, dismissed it, anything like that. It is just saying, hey, Luci Ruiz has a non-payment of rent. I'm moving to evict her. Here's my filing about it. Um, in the state of Georgia, as it currently stands, because that is a civil court record, it is available to the public for a lifetime. There is no like statute of limitations as to how long that's on someone's record. It is a lifetime record. Um, and that means that tenant screening companies as well as credit companies can readily access that information. And with the rise in AI in particular, that has become a major barrier to tenants being able to access stable rental housing because AI bots can easily just get into these court systems and pull these records. And what we have found, researchers have found, as well as anyone who works with renting families, is that a lot of times these records are not even accurate, or were not pursued. They were resolved in the tenant's favor. The landlord moved to dismiss it. So just the mere, hey, this was filed against me one day is preventing these families from being able to access housing. Um, and so families are often surprised to learn that the filing itself may appear on their record. We hear like, I, I beat that case or I mediated that case with my landlord. Why is this still a problem? Well, it's because that filing is still on your record. That's why it's still a problem. And they're not seeing the outcome of it. They're just seeing that there was an eviction filed. So that indicates that there was a problem when you were renting, and therefore you're a less desirable tenant. The tenant may have paid, reached an agreement, like I just said, or won the case, but they're still experiencing this screening consequence. Like housing advocates say scarlet E on your tenant reports, just like the scarlet letter, it's the scarlet E. But just going back to the GSU study, eviction records, eviction filing, sorry, distinguished from record. They found that 33% of surveyed extended stay families identified previous evictions as a barrier to permanent housing. And that was the third cited reason as to why these families are having to resort to extended stay hotels rather than traditional rental housing. So this is why an eviction case can become a child welfare issue long after the immediate threat of displacement has ended. So not only has the child experienced impacts from just the mere displacement of being out of that home, this is a long-term effect because it is preventing their family from being able to secure future housing or access future housing because of that one-time issue. So I would love to prompt the group to just either think or feel free to share either in the chat or just unmute or raise your hand. Where do prior eviction records show up in your work? Are you seeing this with like housing searches, reunification planning, transition age youth? Because fortunately, our younger renters tend to see a heightened risk of this happening to them. Are you seeing this with hotel placements or something else? But where does this eviction issue show up in your work?
And feel free to put it in the chat or even come off mute is good too.
Mm-hmm.
I'm sorry. Can you tell me, say that again? Like, what do you mean
Yeah.
where the eviction issue come up?
Where are you seeing prior eviction records showing up in your work, like when you're trying to provide services to a family?
When we're
So like,
trying, okay.
yeah.
In my work is when I'm trying to help families find housing. Not only is it the bad landlords here, it's the storms that we've had that have
Mhm.
destroyed a lot of the homes. So people who may have had somewhere stable now have to move, and you may see, and it could be it's like evictions from like 2 years ago, 3 years ago, and you just like, why is that even like? How's that even still there? Like, who's looking that far back? You know.
Yeah.
So it's when you're trying to help families find somewhere stable to live or somewhere better to live.
Right, right. Thank you for sharing that. And your area in particular experiences that unique challenge of natural disasters impacting a family's ability to stay in their current home and then how that impacts.
Mhm.
Yeah. Anybody else?
I also saw in the chat, just when families are trying to obtain housing.
Yeah, and that's usually where it's going to come up because pretty much all landlords require these tenant applications now, and they heavily rely on these tenant screening companies that use AI that will pull these court records from years ago somehow. And we've seen where families don't even know that something was filed against them because they resolved it with their landlord. So
I'm seeing
let me
one
get in.
more.
Yeah, yeah.
Sarah, Sherry put parents can't get leases due to past evictions or are homeless due to an eviction, which impacts their ability to have safe and stable housing requirements for defects, for children to
Mm,
remain in the home or to be returned to their home. So that kind of cycle of what I think Chantel was talking about at the beginning, fearful to say anything because they might be evicted, and that could result in a report to Child Protection Services, or just staying in that home and having unsafe conditions in that home that you don't want to report also being reportable. So, a hand slap or something kind of out of their control either way.
yes, yes. And this is such a bigger discussion of how do we lessen that stigma that these families are experiencing, that fear of I'm experiencing a housing instability issue, but I don't want to tell anybody because I'm in fear of losing my children. Which we could talk much more about that, but I'll save it for now. Thank you all for sharing that. So, Senate Bill 406, it is available. Not yet. It goes into effect January 1st of 2027, and it's not automatic. So the reason it has such a late effective date is the lawmakers did want to give the court system sufficient time to get their process in order. We are working with the courts by creating something called a bench card, which is really a guide for courts. And we're also working with legal aid and the other legal organizations across the state so that we can develop some templates that tenants can use so they aren't having to solely rely on like retaining an attorney, but may be able to actually seal the, I'm going to use the word seal, but that's usually not the best word for this, but seal their eviction record on their own. Because in order to do this, it will require them to go to the court wherever the eviction was filed. That's typically the magistrate court or the municipal court, whoever has authority to hear the eviction where the property was located. So like for me, I'm a renter in DeKalb County. So if I had an eviction in DeKalb County, I would file a motion and request a hearing before the DeKalb Magistrate Court. And the court, this is completely discretionary. The court is not required to seal a record. So it is totally up to the court what they want to do. But in order to even have the court hear you, like I said, you have to file a motion and then a hearing is held. And the court has the authority now to order records relating to a dispossessory eviction proceeding to be made unavailable to the public. So that is key. That is why these screening companies and all these other actors are able to get this stuff, is because this is available to the public upon filing. And there are three circumstances where the tenant may be eligible to file as of January 1st of 2027, when they can start doing this. The first one is the eviction proceeding resulted in a judgment. So that means it's not just a filing hanging out. Like there was an actual judgment and order of eviction or in favor of the tenant. I shouldn't say an order of eviction because they weren't evicted, but there was an actual judgment finding in favor of the tenant in that matter. They have the right as of January 1st to file a motion to have that whole case made unavailable to the public. Then the second circumstance is when the judgment was satisfied in full. So even though the case did not go in the tenant's favor, They have since paid the judgment in full, including all interest and costs. So they owe nothing more. The case has been resolved. They can also go file as of January 1st of 2027. Then the third one, which we're going to need to probably work to tweak a little bit because as lawyers we're kind of hesitant with this one, but just reading the law as written, this is 7 years have elapsed since the filing of either a dismissal or a judgment paid in full with interest and costs. So things that we are still trying to understand right now is when you have a dismissal, that's almost in the tenant's favor. So why do you have to wait 7 years? That is still something we are trying to work out, particularly with legal aid, because legal aid are the experts on this. They right now are able to use a court rule in some counties to get records sealed as well. So that's why they're able to inform what this is actually going to look like in practice. And I will continue to share resources as we develop the knowledge on this so that we all know what is available for clients when this goes into effect. And then also the judgment, because that is very similar to circumstance two. So it is also a question of how does that play out differently than circumstance two. So those are ones, just keep them in your head, but we'll provide more information once we know more about it. And we will continue to advocate for this to become an automatic process because right now it is on the tenant to know whether they qualify and then to actually go to the court and file a motion and request a hearing and attend the hearing. We'd like this to be automatic anytime an eviction is filed because a big problem can be this pre-filing issue. I know I'm starting to run out of time. So I just do want to make sure, and you all will have my slides at the end, but I do provide just some practical stuff to keep in mind related to this protection, since you all are our frontline army working with people maybe experiencing these issues on a daily basis. And just quickly, this is something that will be shared with you after this webinar. Georgia Appleseed has developed a healthy housing advocacy toolkit. And I mentioned this, I believe, earlier in the presentation, but it provides resources, talking points, information that individuals can use to advocate in front of their landlord all the way to the Capitol. So it's a really good thing just to initially provide to clients when they come to you so that they can start just understanding, and being empowered to use that resource and advocate for their family. And we have it available in various languages. And just the 4 R's for housing response that are important are, recognizing the specific issue that may be being triggered for the client, recording, helping them preserve anything that they may need to pursue that issue effectively, responding within your role, so making sure you can connect the family to effective resources, like connecting them to emergency assistance, like your local COCs can be very, very helpful for getting a family rapidly housed. Coordinating school stability support, reaching out to the school, getting in touch with the McKinney-Vento liaison, making sure the family knows about that, and just various other things as well. And then upon referral, also following through, making sure you're not just giving a phone number, but that phone number actually answered the phone and the family was able to connect with them. Or if they weren't, maybe that's not the best referral source, but just making sure that they aren't just left on their own. And core message, a referral is not merely giving someone a phone number. The more stressed and displaced a family becomes, the harder it is to navigate several disconnected systems. I think we all can agree with that, how frustrating that can be. Just get circled around. But we can move now to just if there's any questions people may have in the last couple of minutes or anything you want to discuss. I'm very open to that. I've also provided, this is my contact information here. Feel free to email me, call me. I'm a resource. If I don't know, I'm happy to refer you to any partners that may be able to help. As a disclaimer, I mean, I do not provide direct legal services in my role at Georgia Appleseed. However, I do work with partners that do. So happy to try to help you make those referrals as well.
And thank you so much. Lucy, we had one request for paper documents. I have their address. I'll email it to you afterwards, um, with their name for those. And then I'm also going to put in the chat box the evaluation for this presentation. You must complete the evaluation to receive a certificate of attendance. And I also wanted to invite everyone to our annual conference, the Georgia Conference on Child Abuse Prevention, that's happening September 16th in Peachtree City. I have the link there. If you have any final questions or thoughts for Lucy, we're seeing some thank you and great presentation in the chat box for you.
Thank you,
And I want to
everybody.
echo that, staying up to date on some of those newer laws, especially to empower families that we're serving with those actions in there. And I will be sending out a follow-up email probably early next week with all the resources from this webinar, but it'll all also be posted on our website under webinars. You can find the recording, slides, and additional links and resources that Lucy discussed today.
Well, thank you, everybody, for listening to me for an hour and a half and attending this webinar and being so engaged. And Jill, I specifically, I want to thank the Positive Childhood Alliance for hosting me today and just having me share these housing updates and advocacy materials. It was a pleasure to be with you all.
And one more thing before we head off, anything kind of upcoming for this next legislative session that people could look out for?
We do expect there to be probably some stuff related to extended stay hotels. This bill has come up a few times where right now there's a court rule that in certain circumstances, extended stay hotel residents may enjoy the same protections as tenants. And lawmakers have been sponsoring legislation to prevent that court rule. So it's come up 2 times. We expect it to come up again, which can be something that it's really important for anyone who works with these families to weigh in on. Then we also expect the bill related to homeless service funding to come up again. Representative Casey Carpenter's bill, that's come up a couple times. So we expect that again. Hopefully it'll get passed this session. And let me think what else. Some other bills that aren't as jazzy as fun, but kind of a response to the Federal Road to Housing Act that recently went into effect, but to curb some institutional corporate landlord ownership of Georgia single family rental homes and to allow local authority to hold them more accountable for habitability conditions. That's something Georgia Appleseed is intending to advocate for this year, is local authority to better intervene in those issues. So a lot to come.
Always, always. Well, thank you again so much, Lucy.
Yeah.
We'll reach out, but if you haven't yet, quickly grab her information. And I'm going to close up. Have a great one, everyone.
Awesome. Thank you, everybody.
Bye-bye.